record. So we are now recording the presentation. So it will be available on the website by tomorrow. So if you need to review this, you can go back to the website, click a link, and watch this video of tonight's presentation. I'm going to try one more quick thing before. There's how. Not sure how I ought to make you a moderator. So, okay. All right. We're talking about Dodd-Frank tonight. As most of you know who have been on the webinars previously, if you have a question, you can raise your hand by pushing that little raise your hand button. I will then turn on your mic. So you have to have a mic if you want to ask a question verbally. If you don't have a mic, you can type in a question just in sort of the chat feature. And then we'll look through the questions. Just a quick question. Mike's asking, what's the site? I'm assuming you mean my website? I don't know. Mike, if you could clarify that question, we'll get back to you. Okay, Dodd-Frank. Not a big deal and a big deal. Really, it is, if you know what you're doing and you're doing things the way we would normally do them as good, educated investors, then most likely you're going to be fine. And it's really not something to worry about. Certainly don't lose sleep over this. Don't stress about it. There's nothing criminal here. There's no criminal penalties, or you're not going to go to jail if something like that. The fine can be high, but at the end of the day, we all know, cost of doing business, and sometimes we make money, sometimes we don't. So the first thing I want to just say is make sure that you just keep doing what you want to do. Go out and make money, do the best you can, try and comply where you need to comply, and just focus your attentions on making money and doing deals. That's what we do as investors. So that's the focus. But I tried to create an outline that is really simple to understand how this kind of all applies. Now, disclaimer here, which I have to give. Yes, I'm a lawyer, but this is not legal advice. You are not paying me for my opinion on any particular matter in this. So do not rely on it as legal advice. Also, as a disclaimer, this law just took effect on January 10th. It set up a Consumer Protection Board, which has the task of understanding it and applying it and issuing statements on the fine details and listening to complaints and discrepancies within the statute and resolving those. And of course, there'll be litigation, which will then clarify even more things. So at the end of the day, there's a lot of stuff that we still just don't know. And we don't have a lot of answers. And I know Dusty has attended a number of events. I've attended events. I've read numerous things. And I still see conflicting opinions. I'm going to highlight those where they're conflicting. You can get, like they say, you can get 6 lawyers in a room and give 6 different opinions. But we're trying to get the best information we can, the most up-to-date information we can, as things get settled and we get more clarification on things. I will certainly let you know, because that's my job, is to kind of keep you informed over time. Nothing in the law is permanent. Things change all the time, just like the LLC laws have changed very dramatically here in Utah, and we adapt. I change my business, my forms, to adapt to changes in the law, etc. So just kind of be aware of that. You should be able to see this. Oh, look, there I am. Holy cow, we're going to move that over here. Okay. And there's not a lot of light in here either. I will have Ken send this out to all of the attendees tomorrow. So you'll get this sheet. But this is pretty simple that you could probably take notes on while I'm talking to you. And jot down any questions you might have as we're going through this. The first thing I will do is discuss everything, maybe about 30 minutes, and maybe not even that long. And then question and answers after that. So the first two things on this list, out of scope and in scope, you have to understand what the law is. If something is within the scope of the law, then the law applies. If something is outside the scope of the law, then the law does not apply. And the reason I am doing both of these is to clarify that if you are within the scope of the law, there are exemptions. Now, what exemptions are, and this is where some of the discrepancy comes from, even if you are exempt, you're still covered by the law. The law still applies to you, and it just applies in different ways. So, but if you're out of the scope of the law, then you don't even have to know anything about Dodd-Frank because it doesn't apply to you. If it does apply to you, then we're going to discuss how it applies and what you need to do and where. So what is not covered under Dodd-Frank? Most of what you do is not covered in the world of real estate investing. So I listed most of those there: bird dogging, wholesaling, flipping, hard money loans, real estate commissions, property management, and lease options. And I put a little star by lease options. So if you're doing any of those things, Dodd-Frank doesn't apply. So don't worry about it. The reason lease options is starred is some lease options can look like a seller financing deal. Now, I don't worry too much about this, and I recommend my clients not to worry too much about this because I am hoping that they have been good, educated investors, and most of you online are, which means your lease options that you have been doing should already be true lease options and not a disguised seller financing. Anyone who comes to me to do a lease option, in other words, to sell on a lease option, and I do the documents for them, it is a true lease option. What might make a lease option look like a disguised seller financing? There's a number of things. The biggest criteria is debt reduction. Whether or not the payments, the lessees, these are the tenants, the buyers, if any of their payments are going towards the purchase price of the house, or to pay down any part of what might look like a loan, then it's going to look like a seller financing transaction. So how do we get around that? How do we make sure that our lease options are true lease options and not a disguised seller financing? First, do not take an excessive down payment. The bigger the down payment, or the bigger quote unquote lease option amount, that $5,000, $10,000 that you want as an option payment, the bigger it is, the more it's going to look like a down payment to the purchase price. When you write those agreements, make sure that that lease option is a true lease option payment and it is not being applied towards the purchase price. So don't say purchase price $100,000, tenants will pay a lease option of $5,000, and which will be applied to the balance, to the purchase price at closing. Don't say that, okay? Lease options do not get applied to the balance at purchase because that would be a seller financing. That would be a down payment on a seller financing transaction. A lease option is nothing more than a payment to secure the option to purchase, okay? So those are the two notes on the actual option money. Make sure you have two separate contracts, which you should have been doing anyways. One is a lease agreement, and it is nothing more than a lease agreement. And the other is the option to buy agreement. So make sure those are separate documents. Two are, no, I have three now. Three, no rent payment goes towards paying down the purchase price. So don't say rent is $800 and 100 of it will go towards the purchase, will be applied towards the purchase price if you buy the house in 5 years, okay? That's debt payment. That is a monthly payment that is going towards the debt, and that is what mortgage loans do, right? You make your payment, some of it's interest and some of it goes to principal, and you're paying down the debt. So don't do that. And then finally, and we can probably go through a dozen different things. The other big one is don't let the tenants do capital improvements to the house. I don't recommend it. Don't let them remodel a bathroom. Uh, Now, I would recommend that before Dodd-Frank, because if you remember, if you're in a lease option, you really want to avoid problems. And the bigger the down payment you take, the more you apply that towards the principal and the more capital improvements you allow them to do. In other words, the more money that they're putting into the house, if it turns out that they can't purchase it at the end of that option, they're going to be mad. They're going to be upset. They're going because they're about to lose a whole lot of money. And the more money they're going to lose, the more likely they're going to hire a lawyer and try and claim that they have ownership rights to the house. So in all lease options, I've always recommended make sure it is a true lease option. They are tenants. Treat them like any other tenants, and you're good to go. So we'll leave that at that. If you're doing any of those kinds of real estate transactions, Dodd-Frank doesn't apply. Ignore it, move on, and if that's all you're going to do, you can turn off the webinar right now because nothing else is going to apply to you. Now, what does Dodd-Frank apply to? Well, it applies to seller financing. Seller financing is when the seller becomes a lender who is loaning on terms money for the buyer to buy a house. So you're a lender, and this is what Dodd-Frank was meant to apply to, lenders. And of course, its core function was to apply towards commercial lenders. These are the banks that were giving out lots of loans. Many of those loans weren't very good. The buyers weren't qualified. People got screwed. They had these, huge, high variable rate loans, et cetera, et cetera, et cetera, part of the whole bubble crashing 4 or 5 years ago. And if you've been in real estate long enough, you remember exactly what that was and why it happened. Well, the law was designed to prevent that from happening again. So it applies to lenders, and it applies to lenders, mortgage lenders, people like Matt Atkinson, and they have their own attorneys telling them how they can now do their loan. So we're not going to really talk about the rules that apply to lenders, traditional lenders, or mortgage brokers like Matt. That's his deal with his attorney. I'm talking to investors like myself and like you, and how it applies to us. So if you're doing a seller financing deal, what might be a seller financing deal? Well, seller financing. If you do an all-inclusive note and deed, that's seller financing. Or just seller financing. I mean, it's pretty straightforward what it is, and we all do it. So Dodd-Frank applies to those transactions. It's the transaction that it applies to. And if you are doing anything in seller financing, Dodd-Frank does apply. Even if you are exempt, it still applies. The question is, what rule applies? We're going to start off with assuming you are not exempt. We're assuming that you fall 100% square in the crosshairs of Dodd-Frank, and you have to comply with everything, because that'll be the easiest thing to do. All right, so let's start off with everything you need to do, and then talk about the exemptions and some ways around it. Because it's really, at the end of the day, not that big a deal. Okay? There are 4 major categories of things that you have to comply with if Dodd-Frank applies to you in your seller financing situation. So let's talk about, we'll talk 1, 2, 3, 4, and then we'll get a little more detailed. First, verify the borrower's ability to repay the loan. This is qualifying your buyer. Okay? Second, you have to use a qualified loan. Okay? So your buyer has to be legitimate. Your loan has to be legitimate. And then third, if you do have to foreclose, then you must wait 120 days and give an option to cure, to get caught up. You have to discuss loan modifications, loss mitigations, offer them a deed in lieu. These are ways to kind of get around it. But the rules are that if you do have to foreclose, you have to wait 120 days before you can foreclose, and then you start the foreclosure process, which could take a few more months. And finally, there's no forced arbitration clause in your note. Most of you don't really use a forced arbitration clause in your notes anyways. In other words, your promissory note would say something like, in the event of default, the parties may submit this to arbitration rather than the parties must submit this to arbitration. There's a very similar clause, by the way, in the Utah Rep C. So if you want some examples of what an arbitration clause looks like, just go to the Utah Repsia and look at the arbitration clause. So we're not going to worry about 3 and 4. Okay. So really, if you're doing a seller financing deal, you have to qualify your buyer and give them a qualified loan. So what is qualifying your buyer? It's really not that big a deal. This is 8 things that are suggested that lenders should consider. They are not requirements. You don't have to do every single one of these, but the burden is on you to prove that you verified your buyer, that you have a qualified buyer. So these are sort of 8 guidelines of things that you can look at and then use as proof that you did qualify your buyer. Okay. Look at their current or reasonable expected income and assets. Okay. Current employment status. Monthly payment on, look at, the monthly payment on the loan you are making them. The monthly payment on any simultaneous loan that you might be making them. This kind of got snuck in there from the old 80-20 loans. So what the guidelines are saying, if you were doing like an 80-20 loan, look at the payment on both of those combined rather than separate. Because obviously, someone might be able to easily make the first, but making the first when they have a second might be difficult. Monthly payment on any other debt-related mortgages. Do they have other homes, other rental properties? So look at other mortgages they may have. Look at their current debt, alimony, child support, etc. And then do a debt-to-income ratio. Typically, most of the real estate gurus, etc., are saying 43% max debt-to-income ratio. And then pull their credit history and look at their credit report. Okay, so these are all things that you can do to verify and qualify your buyer. And these are not hard things to find. You should probably get these from third-party sources. Pull credit from a third party, like Experian. Ask for bank statements that actually, that come from the bank. Look at the actual statement of their mortgage. If they have another mortgage, look at their last mortgage statement. Okay, don't take their word for it. Look at it. Now, most of you should be doing this anyways, I hope, to at least some degree, right? You're not going to just sell your house to some Joe off the street who says, oh, yeah, I'm going to buy the house and I can make the payments. Awesome, dude. Let's, put you under contract and move you into my house. Okay. Hopefully you have been doing something to qualify your buyers and get good buyers in your home, right? Your goal is not just to throw somebody in there, but to get someone in there that is going to end up buying it and making the payments on the loan, completing the terms, and then taking the house, right? And so that you get your cash. That's how you make money. Okay, you don't want to have to evict or to foreclose or to renegotiate or anything like that. You want good buyers in there. So that's something you should have been doing anyways. So now just do it better. Keep the records. Ask for the statements and just verify this. Okay. So again, verifying and qualifying your buyer, not such a big deal, but now just do it. Now, second one, and this is kind of the bigger one. This is kind of where this is the one that really kind of has real estate investors ticked off. Parts of this anyways. What is a qualified loan? What kind of loan can you actually give? Okay, now that you've qualified your buyer, they're legitimate, they've got good income, they can buy it, and you're comfortable with that. You give them a good loan, a qualified loan. What does that mean? One, no negative amortization. But I don't know any one of you that are doing negative am loans anyways. In fact, if any of you are doing negative amortization loans, come see me because I'll slap you across the face. Okay, so you shouldn't be doing that anyways. The loan has to be 30 years or less. How many of you are giving loans greater than 30 years? None of you. And if you are, again, slap you across the face. You don't want to hold a note for more than 30 years, so you're already in compliance with that one. C, no excessive prepayment penalties. I don't know any lender who puts any prepayment penalties on their notes, right? You want them to prepay. You want them to pay off early. So just don't put in a prepayment penalty. You can put them in, and I gave you some notes on what may be termed excessive, but my suggestion is don't put a prepayment penalty on at all. That's the easiest way. 4, it can be a variable rate loan, sort of. My suggestion is the real estate gurus, most of them suggest have a fixed rate, period. Now, most of you are using fixed rate loans anyways. Most of you aren't doing variable rate loans. So again, that's not a big deal because it's not something you were normally doing and now you can't. Most of you are doing fixed rate loans. But now it's kind of required to do a fixed rate loans. What can you do? The suggestion is, kind of in compliance to the rule, is fix it for the first 5 years. You can then raise it 2 points a year for a maximum of 6 more points. And that's actually kind of a good thing because it kind of helps alleviate another problem. So again, for most of you, just create a fixed rate loan. If you want to have some kind of variability in it, fix it for the first 5 years, and then put in an option, in the note that the lender may raise the interest rate 2 points in year 6, 2 points in year 7, and then 2 points in year 8, and then you're done. You can't raise it anymore. Okay, so that's not such a big deal. Number E, or what is this, 5? Creditor must verify the income, assets, and debts with the third-party reports. Okay, that's already taken care of up here because you've already done that. You've already verified your borrower. You don't have to verify employment or credit history. Again, remember, these were suggestions. These are things that you can do to prove that you qualified your buyer. So do them anyways, right? It's not required unless it is to verify their debt-to-income ratio. But again, suggestion, do it anyways. Verify their employment, check their credit history. Those are very simple things to do. You can do them in 10 minutes. Get a report from somebody that you can now rely on because it's a third-party report. Keep it in your file, in your folder, and you've complied with that part of the regulation. Here's the last one. In your note, no balloon payments. This is the one that has most real estate investing educators the most ticked off. The rest of these, they were already doing anyway. Everything from 1A all the way down to 2G, pretty much they were already in compliance. But almost all of us doing seller financing deals have balloon payments, right? We did 5-year notes or 3-year notes or 7-year notes. Then they had to pay it off in full. That's a balloon payment, okay? So if you did a 7-year note with a payoff in 7 years, that is a balloon note. Those are now banned under Dodd-Frank. You can no longer do balloon payments on your notes, okay? So in worst case scenario, if Dodd-Frank applies to you, then if you comply with all of this, 1, 2, 3, and 4, you're good to go. And really, 4 is not a big issue. That's just something you can just put in your notes. 3 only comes into play if you have to foreclose. So really, it's just 1 and 2. As long as you verified your borrower and you've given a qualified loan, you've complied with Dodd-Frank. Okay, now let's talk about exemptions. Are we exempt if we're doing a seller financing transaction? Remember, Dodd-Frank applies to all seller financing transactions, period. All of them, okay? It does not apply to bird dogging, wholesaling, flipping, hard money loans, real estate commissions, property management, true lease options, etc. So no worries there. If you're doing seller financing, Dodd-Frank does apply. But they built in exemptions. And here is, I've heard a couple of different attorneys, and I've heard a couple of different real estate educators, and they kind of conflict on this. If you are exempt, if you fall under one of the exemptions, some believe that you are exempt from the law, which means you don't have to comply with any of it. The prevailing opinion, particularly from the lawyers and from the guru, the real estate educators that, I seem to trust a little bit more, and that's just a personal opinion. And it's my personal opinion for now, even if you are exempt, there are still rules that apply. What they believe is that as this shakes out and as this Consumer Protection Board starts to look at this, they will clarify the law, and that if you are exempt, you are exempt, and you don't have to comply with any of it. And if you're not exempt, then you have to comply with all of it. But right now it looks like that even if you are exempt, you still have to comply with some of these rules. So what are the exemptions? no more than one seller financing deal as an individual, estate, or trust. Okay, this is now as a seller. This is if you are the seller of the property. You can sell one piece of property a year, if as in your individual name or through an estate or a trust, because estates and trusts are kind of considered individuals. Okay. Conflict here, though, and this is kind of why it's in there. There was disagreement between the attorney and the educator. The attorney was of the opinion that this really applied to a personal residence. You could sell a personal residence and be an exemption. The real estate educator or the investor thought that you could sell any of your investment properties under this exemption. Okay, so one is an individual, no more than 3 per entity. Okay, again, there's a conflict here. And then I get some of this. This line comes from Ron LeGrand, who many of you know. Ron's attorney said that it was 3 total, period, regardless of how many entities you had, because you were the common owner of all those entities, that it was just 3 total. So you could do 1 as an individual and then 3 in all of your LLCs, so a total of 4. Ron believes that the way it's described and the way it's written, that you could do 3 in every one of your entities. So if you had 7 entities, you could do 3 in each one, that's 21. And it comes down to, I mean, the reason they disagree is this common ownership and control. We look at things like that a lot in the law, particularly in corporate law and asset protection and who the owners are, et cetera. And so if you look at some definitions of common ownership, the attorney's actually right. But if you kind of look at the statute itself, it kind of looks like it's 3 per entity. So again, I can't definitively tell you what that answer is, but Ron LeGrand is doing 3 per entity. So if you do that, you're in good company. Exempt commercial deals. This does not apply to commercial deals. So if you're buying or selling commercial real estate, you're exempt. It does not apply to loans to non-occupied occupiers. So this really covers the situation when you are purchasing a property through seller financing from the current owner of the house. So this is when you're buying on seller financing. Okay. If you're buying in the name as an investor to rent it out, you're a non-owner occupier, and Dodd-Frank doesn't apply. Also remember this. Dodd-Frank was written to protect the borrower, right? This whole thing came about because of the fraud that was, done on investors and buyers and borrowers and homeowners, during the 2000s. And so the whole point of this entire act is to protect the borrower. If you're buying on seller financing, you're the borrower. Okay, you're the ones who's protected. So if you don't comply with Dodd-Frank, who's gonna tell? You're the only one that could tell. And if you don't want to tell, you're the investor. You got what you wanted. So just remember that. Remember who's being protected and who has the rights to complain. And if you're the buyer, then if you don't complain, then no one's going to know. And then the 5th exemption is when both the buyer and seller are entities. Now this really helps when you're selling. If you're selling to another investor, that's exempt because you're selling your entity to their entity. If you're selling even to an end buyer, if they want to, they can buy it and then they can sell it to an entity, and maybe they can buy it that way, and you can be exempt. So those are the exemptions that everyone's kind of talking about. Don't do any more than 1 as an individual, or 3 in your entities, or non-owner occupied or entity to entity transactions. These are exempt. But at the end of the day, I'm not so concerned about those exemptions, simply because the general consensus is that even if you fall under one of those exemptions, the rules still apply. And these are the 3 rules that most educators and most people looking into this say still apply. No balloon, still can't do a balloon. So no 5-year term with the balloon payment at the end of 5 years. Fix your rate for 5 years, so no variable rates, and qualify your buyer. Now, again, fixed rate and qualifying your buyer is something you were already doing. So the only real issue is this no balloon in your loans. That's really You only have to worry about, and you need to worry about it even if you are the buyer taking a property through seller financing. Because even though that owner is selling to you as a non-owner occupied buyer, this still applies. You cannot take that loan with a balloon payment. Now remember, who's protected? You are. And if you don't complain, you can take it on with a balloon payment, and no one's going to know. So that's kind of the kicker in all of this. Most of the educators are getting around that. The way they're getting around that is they are using this fixed for 5 years, raise 2 points a year for the max of 6 points. Because if you just think about that, if you have a 6% interest rate and it's fixed for 5 years, in year 6 it's going to go to 8, year 7 it's going to go to 10, and then in year 8 it's going to go to 12% interest. Okay, no one's going to want to hold a 12% interest loan. That's a huge inducement to get them to pay it off early. Because remember, there's no prepayment penalties. They can pay it off anytime. So your goal is just to encourage them to pay it off early. Other educators are talking about giving discounts. If you buy it within 5 years, I will discount 10% off the purchase price, which again is inducing them to prepay the loan rather than to carry it out to term. So again, there are some workarounds. Other things, and it's just a few more notes, kind of as I went through my notes from all my education to kind of summarize for you. Always get a disclaimer from your buyer, acknowledging that the transaction didn't fall under Dodd-Frank, even if it did, simply because remember, who's going to complain? The buyer. So the buyer's the one that has the issue here. And if they have a signed document that says that Dodd-Frank didn't apply and they're not going to hold you liable for the Dodd-Frank, that's at least a piece of evidence that they're going to have to overcome to come after you. So it's probably not going to protect you at the end of the day, but it's going to make it much more difficult for them and possibly mitigate some of the damages so you don't end up paying as much. You can modify loans made prior to Dodd-Frank. So if you have any loans prior to January 10th of this year, you can modify and not worry about. You can assign loans. There's no regulation on assigning loans. So even loans subject to Dodd-Frank, you can assign without restriction. But remember, the loan itself, if the loan originated after January 10th, that loan still needs to kind of be in compliance, which brings up, if you're buying on seller financing and you're buying from a homeowner and that homeowner wants, a balloon payment in 7 years, you know that, well, you can't have a balloon payment, but you put one in anyways because you were the buyer and you weren't, you're not going to complain. So no one's going to find out. You're going to pay it off in 7 years. But then in year 2 or 3, you decide that, hey, I don't want to manage this property anymore. I want to assign, the property or sell this property under another seller financing or assign this note or something to somebody else. At that point, you're transferring a loan that's not in compliance with Dodd-Frank to another buyer who might complain, right? And your seller is probably not going to be too happy at that point. So remember, you can assign the loans, but remember the loan itself, if it originates after January 10th, does have to be in compliance with Dodd-Frank. Other real estate educators are using land trusts and LLCs to kind of get around this. You can put a property into a land trust and sell off the beneficial interest, which means you are not selling real estate, you are selling a beneficial interest. Others are using LLCs and putting the property in an LLC and then selling off the membership in the LLC. If you do that, please talk to me before you do, because you may, depending on how you sell it, you may have securities issues because you're selling essentially interest in a company. Essentially, you're selling stock. Another way to do it, lease options. Again, if it's a true lease option, it's not covered under Dodd-Frank. So that is a way to do, what you may have done is seller financing, do it as a true lease option. One, you maintain title, so you maintain control over that. You don't have to foreclose, you can evict, and you can still kind of get the same result where they're making your payment, your monthly payment, and then they're obligated to buy that property at X date, which can be 1 year, 2 year, 4 years, whatever. And so a true lease option could be a workaround. Finally, there may be some state laws we don't know yet, because the states now are digesting all of this, and some states may have additional requirements and stuff. So as soon as we hear more back from the state of Utah, we'll get to that information. Okay, there was Dodd-Frank in a nutshell. I hope it was understandable. Sometimes I never know. So what we will do is we will now open it up to questions. Will you increase the document? Oops, really? Jordan, what are you viewing this on? Yikes. Okay, Jordan, sorry, I didn't see that earlier. I'm going to leave this up. That's pretty big. Good grief. I have like a 40-inch screen, and it's huge to me. So get a bigger monitor there, Jordan. Okay. So if you've got a question, you can type it in the chat box, or you can raise your hand by clicking that little button, and we will take questions and hopefully answer them. Okay. Okay, Christine, I've unmuted you, so why don't you tell us your question? Now, Christine, you got to have a microphone turned on your computer. So if you don't have a microphone on your computer, then go ahead and type in the question, Christine, because I can't hear you. Okay, so if I buy a product, this question from Kirk. If I buy subject to, this does not fall under Dodd-Frank. No, that does. Buying subject to is seller financing. Assuming I'm understanding your question correctly, but assuming that you are doing a wrap and you are wrapping a mortgage or a note to the seller, and you're wrapping it around the underlying mortgage, which is what typically subject to means, then yes, buying subject to, buying with an all-inclusive note and deed, these are seller financing transactions, and yes, Dodd-Frank does apply. Question, I came in late. Can I get access to the recording? Yes, you can. The recording will be up tomorrow, sometime tomorrow morning. So yes, you can get access to the recording. Okay. Danny, you got a question? Funny, I know Danny. I wonder if we may be having technical problems because I haven't been able to hear anybody on their microphones. I wonder if there's something I need to do. See your screen. People can see you. People can hear you. Not sure why I can't hear anybody. So Danny, with your question, please go ahead and type it in. Okay, Leslie. But only if it's owner occupied, correct? I don't know what you mean by that, Leslie. I think I need more information on your question. If it's owner occupied, meaning the house you are buying, if you're buying on lease options, you're doing a wrap, if you are taking it as non-owner occupied, you are exempt, but even though you are exempt, the rules still apply. I know that is very confusing. It's illogical. It makes no sense why they would create an exemption to a law, but then still make the law apply. So the best I can tell you right now is, yes, the law applies even if it's a non-owner occupied situation. But again, the general consensus is no balloon payment, fix your rate for 5 years and qualify your buyer. So that's the best I can tell you right now, is to stay in compliance, just kind of follow the rules until we find out that an exemption is truly an exemption and you are no longer obligated to any of this. And that may very well happen, because that's sort of the consensus is it was a slip up in the law that they created an exemption, but then didn't make you truly exempt. So, okay, Christine Pitts, lease option. Is there a legal way to apply a portion of the rent payment to discount the final purchase price of the home? Yes, but you are not going to. You're not going to apply the portion of rent payment to the final purchase price of the home. Don't do that. Don't say that. Don't write that in. What you can do. Let me give you an example. Probably easier. You want to sell a house for $100,000. You're going to do it under lease option, and you want $5,000 in option money. Okay, and you're fine applying that to the purchase price. Okay. But do not write the purchase price of $100,000, and do not write that the lease option of $5,000 will be applied to that purchase price. Do not do that. Write the purchase price as $95,000. And then the option money of $5,000 is a non-refundable option to buy the house. End result is the same, right? You're still going to get the 100 grand, but you're calling a purchase price of 95 and an option of 5. So to you, it's the same thing, but it's not, but that $5,000 did not go to the purchase price. Now, beware, don't really push those numbers. If the house is worth 100 and then you want $20,000 in that option price, and so you're going to make the purchase price 80 with an option of 20, that looks like a 20% down payment on the house, even if you called it an option. So again, remember my first rule is don't make that option, that money, too excessive. That's hopefully that kind of answers your question. Don't put any rent towards debt payment at all. Just don't even do it. You want to discount the house? Discount it for paying off the debt early. Say if you pay it off within 5 years, I will take 10% off the price. You pay it within 7 years, I'll take 7% off the price. Do not apply any money that they're giving you towards a purchase price of a home. Okay. Jeff, could you explain what arbitration is? That forced arbitration clause in the note. Essentially what was happening, and the reason this is in the law, is during the crash and all of these bad loans were becoming an issue, a lot of the banks were forcing the borrowers into arbitration where they really didn't assert their rights and they really kind of gotten taken advantage of. And they weren't left with the option of actually going to court and having a judge settle this. So they wrote that in that you couldn't force somebody into arbitration to settle this dispute. In other words, you were denying the borrower their day in court. And so the Dodd-Frank Act said, no, you cannot deny somebody their day in court. If they want to go to court to challenge, this loan, then they have that right. So no forced arbitration clauses in your promissory notes. You can put them in as an option that they can elect that, both parties may go to arbitration. And arbitration is essentially you go before a third party impartial, usually a former judge, a former lawyer, former investigator, someone with experience, and each side kind of presents their side, and then the arbiter makes a decision as if they were a court of law. So generally it's a cheaper, faster way to get stuff resolved. And generally I'm a fan of arbitration rather than litigation. Banks can no longer obligate people and force them into arbitration and deny them their day in court. Okay. Yes. Can I get a copy of the outline on the screen? Yes. I will be sending this PDF to everyone who is in attendance today. Actually, Ken will be sending that off to you tomorrow. Christine Pitts asks, so would the term rent to own be a no-no now? Yes, Christine, excellent comment. It is not rent to own. You will never use those words again. It is, I know that when you're talking to buyers, you're going to want to do that because they understand it. They understand what rent to own means. There's lots of rent to own situations, furniture, TVs, etc. Do not use the rent to own because they are not renting to own. They are renters. They are tenants. period. And they have an option to buy at some future date, which they've locked in with some option money. Yes, no more rent to owns. Okay, so is it still possible to buy non-performing loans pre-2014 and modify them? Do the modifications have to meet Dodd-Frank? Ooh, excellent question. Give me 1 second. My answer to that right now is no. I will get back with you on that, and I will send out an email to everybody. The loan originated before Dodd-Frank applied. So Dodd-Frank does not apply to that loan, and you may modify them. I'm pretty sure that is also, yep, you can modify, yeah, right on my notes. You can modify prior loans, and it's not subject to Dodd-Frank. Okay. Okay, Eric, can you explain the 2 contracts you would use to do, I'm assuming lease options, the 2 contracts to do lease options, yes. One would be a rental agreement, the second would the second be, and can you give an example? Yes. The 2 documents you're going to use in a lease option. You're going to use your standard rental agreement that you've been using as a landlord on your rental properties forever, period. It is nothing more than a true lease agreement that if you were the owner of that property, you were the landlord, and you wanted to just rent it out, you didn't want to sell it, you just wanted tenants, that is the first document that you will use. And that lease agreement will not reference the option. It will not reference purchasing it. It will not say anything like, oh, rent will be applied to the purchase price. That document will stand alone and look no different than any other lease agreement you have ever done as a landlord. The second document is an option to purchase. An option agreement is what it's called. And in that document, it will state the purchase price, the terms, the option money, that the option money is non-refundable, that the option money is to lock in their rights to buy this house within 5 years, that if they don't purchase it within 5 years, they will lose the option money. The purchase price is going to be $95,000. If they want to pay it off early, it's $93,000, things of that nature. So the option agreement is a purchase agreement. It's like a REPSI, right? It's a REPSI for the future. It's a very long REPSI. It's a REPSI that's going to take 5 years or 3 years or whatever to come to fruition, but it looks like a REPSI in most of its terms, except for that, what the option is. And that option agreement can reference the lease, which is fine, but the lease does not reference the option. Okay, hopefully that made sense. If the non-performing loan is a HELOC pre-2014, does the mod need to follow? Again, I don't believe so, James. I'm assuming a HELOC, it doesn't matter. The original terms, that loan originated pre-2014, and modifications would not need to fall under Dodd-Frank. Can't totally confirm that, but I would assume that a HELOC would be applicable just like any other loan that may have originated before 2014. So Eric asks, in a lease option, so would you mention the monthly payments, purchase price, and option fee in the option agreement? Correct. Question mark. I would not mention I wouldn't mention the monthly payments in the option agreement. You certainly can. But what I would do rather is in the option agreement, just reference that the optionor has concurrently executed a lease agreement, which and is going to be bound by, which is referenced hereby. Really, that's it. Leave the monthly payments as rent. Okay, if you start putting monthly payments into that option agreement, that purchase agreement, it's going to look like they're making payments towards the purchase price, which would make it a purchase agreement and a seller financing transaction. The option would talk about the purchase price, the option fee, the term, any terms about payment, qualifying, things of that nature, but no monthly payments referenced in the option agreement. Leave that for the lease agreement. Okay. Let's see. Hey, Danny, you there?
Yeah, I'm here, buddy. Can you hear me?
Oh, there's okay. We got audio. Okay, Danny, what's your question?
Awesome. I was just typing it. Maybe you already explained this. Sorry, can you hear me good?
Yep, I can hear you fine.
Okay. So, do the Dodd-Frank limitations apply only when you're the seller or in a seller financing transaction, or do they also apply when you're the buyer? Like, is there like a cap that you have as a buyer,
Dodd
or only
Frank,
as a seller?
yeah, Dodd Frank applies to the transaction itself, irregardless of who the buyer and seller are. So it applies to the transaction. So yes, it applies when you are the buyer, and yes, it applies when you are the seller. Now, what rules apply depend on essentially what we talked about here. If you're exempt or whether you're not exempt, but even if you're exempt, that loan, whether you're the buyer or the seller, no balloon payment and fixed rate for 5 years and qualify your buyers.
Hmm.
So yes, it applies to the transaction itself, not necessarily to being a buyer or being a seller. It
Okay. Could
protects the buyers. That's who it's protecting. So the buyers are the ones with the right to complain and the right to sue and the right to damages.
okay. Now, when it comes to like when you're a seller, for example, that you're limited to do only one seller financing transaction as an individual and up to three either per entity or all that, which totals either four or 21,
Yeah,
as you were
exactly.
saying.
Yeah.
Depends on how it eventually unfolds. If I'm a buyer, like if I'm an investor buying seller financing properties, does that mean I also have a limitation on how many properties I can buy under seller
No,
financing?
no, there's no limits to how many you buy because if you
Okay.
buy from seller A, that's his one transaction. And when you go to seller B for the other house, that's seller B's one transaction. And when you go to seller C for their house, that's seller C's one transaction. So no, there's no limitations on buying
Oh,
because
okay.
because it applies to the transaction between the buyer and the seller and who they are. And if that seller is an individual and that's their only one that year, then they're exempt. Does
Okay,
that make
great, man.
sense?
Thanks. Yeah.
Okay. Ron asks, are exemptions 1 and 2 yearly? Yes, I probably should have written that in, and I'll make sure I readjust that form. Exemptions 1 and 2 are yearly, one per year or three per entity per year. Okie doke. How long is this applicable to the loan? Is it the 30-year term? What if buyer's circumstance change, as in lost their jobs? Um, this is long. This is applicable during for forever, and as long as Dodd Frank is an active law, these rules always apply. So if you originate any loan or you do any seller financing from now on, these terms can apply. And if the seller or the buyers lose their job, then you have the same rights that you would always have if they go into default. And if they lose a job and can't make payments, then you still can foreclose, but you have to foreclose according to the terms of Dodd-Frank, which means waiting the 120 days and making sure you give them options to cure. Try a loan modification, negotiate with them to do a loan modification, do a deed in lieu. In fact, Ron LeGrand says, if this ever happens, he's going to call up his lawyer, and his lawyer is going to send an offer for a deed in lieu, and foreclosure, and that saves everybody time and money because the buyers probably, if they can't make payments, they're going to lose it anyways, and so you can just convince them that it's in their best interest, and everybody's best interest is to do a deed in lieu, because then you're not foreclosing, right? You can do that in a week if they agree to it. They got to agree to it, but you can do it. And in fact, all my hard money, all my loan documents now, all my notes, clearly state that the lender has the option of accepting a deed in lieu in the event of default, because that's what you want. It makes your life a whole lot easier. So yes, as long as this law is in effect, you're bound by the terms. Oops, sorry, Danny. Hold on, let me mute. Okay, I think you're now muted, Danny. How do we reference Dodd-Frank in the disclaimer? What is the official name or reference? You can reference, you probably just use the words Dodd-Frank. I will see if I can get the actual statutory code, reference, but the Dodd-Frank Act would be plenty. And you could say something like, buyer agrees that this transaction does not fall under the Dodd-Frank Act. You could probably even write in and waives any damages they may have under it. Now, again, that's not going to absolutely protect you. People can't waive away rights they really do have. But, if they think they can't sue, I always give the example with with disclaimers. If you ever go skiing, great example. Go to Alta, go skiing. And on the back of your lift pass, there's just all the little fine print that says you cannot sue for this or this or this. You can, break your arm, you can break your leg and get a concussion, you can die, and you cannot sue the resort. Well, guess what? You can. You can still sue the resort and make millions of dollars. But people think they can't, right? They read that and they think, oh, I'm not allowed to sue the resort, so they don't. There you go. There you have my 2 cents on using disclaimers. So use your disclaimers. If the buyer is making rental payments and not mortgage payments, how do you foreclose on them? You do not foreclose, you evict them. That is the joy of a lease option. If it's a true lease option, you do not foreclose. You evict them like any other tenant. And when you go to the eviction court, and the reason you really do, and the way we've always been doing 2 separate agreements, it was not because of Dodd-Frank. We did 2 separate agreements because we wanted to be able to evict them and not foreclose. And so when you go to court, you need to submit the document that you're using for the eviction. And so you want to submit your lease agreement with the rights to evict, because that's the only document the court's going to look at. If that lease agreement references an option, the court's going to ask for that option agreement and look at that too. And you don't want the court looking at that option agreement. You want to restrict the court to the document at hand, which is the lease agreement. So no, they're making rental payments. You do not foreclose, you evict. Question, Leslie. So if the buyer wants to come back on a lender due to they were not qualified to get the loan, they can do this at any time until the loan is paid in full. Let me quickly review notes on that. If Dusty's around, if she's still online, she knew. Dusty and I actually had different information. It's within 3 years. I'm going to confirm that. They have 3 years to come back and sue. Any borrower on a consumer loan secured by real property has 3 years to bring suit against the lender for failing to consider the borrower's ability to repay the loan. I'm reading right from Ron LeGrand stuff here. So they have 3 years to bring lawsuit. If they succeed, the borrower is entitled to everything they paid the lender for the previous 3 years, plus attorney's fees, court costs, etc. At any time after the loan is made, 3 years or not, the borrower may bring this as a defense to set off any foreclosure action and recover the previous 3 years' payments. So my understanding of that, and I'm kind of a smart guy, if they want to challenge the legitimacy of the loan itself, that they were not qualified and they just kind of get out of it, they've got to do it within 3 years of making the loan. If they are challenging a foreclosure, and they want to challenge the loan during a foreclosure process, they can do that anytime under the term of the loan. So if they want to challenge the loan itself, absent a foreclosure, they've got to do it within 3 years. But if 7 years down the road and you're going to foreclose on them, at that point, they can still challenge it because they're now challenging, they're defending the foreclosure is what they're doing. So the defending the foreclosure can happen anytime during the loan. To challenge the loan itself outright was in 3 years. And my understanding was that the damages would be everything they've actually paid to you as the lender for up to 3 years. Dusty's understanding was that they could get 3 years of payments even if they sued within 6 months. So you've got conflicting opinions on there. Dusty confirmed that with her people. I haven't been able to truly confirm that, other than the stuff I attended. That's the statements that they were making. So hopefully that answers that question. Okay, it is 6:30. I'll take one more question if somebody has one. Ron has one last. This is the last question. If you evict a lessee who has a separate 5-year option to buy, can he still come back and buy at any time within the option? No, because in your option agreement that references that lease agreement, it is going to say, in the event that the optionee defaults on the lease agreement attached herewith, then that person is in default of the option and forfeits their right to purchase the property and loses their option money. That's why the option agreement references the lease, but the release does not reference the option. So one last one from Leslie, because Leslie's my girl. Another word for a lease agreement would just be a rental agreement. Yes. Yep. Lease rental agreement. You call it a rental agreement. That's great. Lease agreement's kind of the standard verbiage, but either one, as long as it looks exactly like the lease agreements you use on your rental properties where you're the landlord and that's all you want out of it. That's what your lease agreement needs to look like. Okay. If there's any other questions, feel free to shoot me an email. Remember that I've got coming up an asset protection class on March 15th. So it is filling up. Their seats are limited. We are going to talk about a ton of information about, in fact, it's probably surprising information because I'm probably going to have a different opinion than a lot of stuff you've heard about asset protection. But we're going to cover lots of different arrangements, more than just the legal stuff, the corporate governance stuff, privacy stuff, and we're going to really get into depth. It's an advanced class. We're not going to spend a lot of time on background. We're going to really hit asset protection hard and answer your questions about using family trusts, family limited partnerships, land trusts, series LLCs, regular LLCs, S corps and C corps, and how property management companies, and how they actually all fit together in a way that works specifically to you, and not here's a $4,000, $7,000, or $60,000 package that covers everybody. I tailor make things to my clients, and so we're going to cover all of those. So I really, really recommend jumping on my website, going to the live education tab, and it's on March 15th. We're doing it in Orem, Utah, in the morning, and then we're doing it in Salt Lake City downtown in the afternoon. So you can pick one that works best for you, and just show up. It's only a $30 registration investment, so very, very nominal fee for education. But it does have a tendency to commit people, and when you're committed, you show up and you really learn and you pay attention, and you take notes, and you'll more likely implement what you learned. So really recommend that. And if there's nothing else, thank you for attending tonight. I look forward to seeing you at the next webinar or the next event. If you have any questions, all you got to do is email or call me. I'm always here. Thanks, guys. Have a great night. And how do I do this? Nope.